So, John, we're delighted you'll be giving the Quain Lectures in Jurisprudence at UCL later this year. Now, the theme you've chosen is personal life and private law. Personal life is a bit of an unusual rubric for looking at private law. It's not economic efficiency, it's not justice of some sort. Why personal life?
Well, I was really trying to stand up for the view, which I'll defend in detail in the lectures if I can, that the moral problems that arise in private law are continuous with the moral problems that arise for all of us in our personal relationships. And you're right, that's not a common view. One of the motivations for it is that there are some philosophers of private law who think that the domain of law and maybe more generally the domain of political organization needs to be kept autonomous from the rest of ethics, and that's very different from my view. I'm what used to be called a legal moralist. I think that the best way to think about the law is as the source of ordinary moral puzzles for ordinary moral agents who just happen to be judges and police officers and litigants.
So you're swimming against the kind of, in one sense, Rawlsian current that wants to strongly divorce political issues from the sorts of moral concerns that we confront day to day. But do you think nonetheless there might be something in that view that has to be incorporated?
Well, it's not just the Rawlsian view. I think there's a longer-standing Kantian view according to which the theory of right has to be distinguished from the theory of virtue. Now, obviously there's something in this view. There's something in almost every view. But the question is how far to take it. So one might agree with this tradition that as soon as we start using coercion or authority or some other special technique, new moral questions arise and our moral position is changed. But I think my suggestion is likely to be something like this, that our moral position is changed only in the way that our moral position is changed all the time by small changes of mode or context. So moving into the domain of authority from the domain of no authority is not that different from moving into the domain of friendship from the domain of acquaintanceship. In other words, it's an ordinary moral shift.
So could you give an example of some idea in personal morality that you think is formative for our understanding of private law?
Well, the thing that I'm going to dwell on most in these lectures, not exclusively, but most, is the way in which we think of our lives as shaped and affected by our pasts. So I've chosen that as a second unifying theme for the lectures, partly because it's a theme that continues to baffle me and puzzle me, and not just as a lawyer, but also just as a human being. Why do we think of our pasts as making such a difference to our presents and futures? And this, I think, is where the lectures will establish the chasm between me and the utilitarians, or more broadly, consequentialists who think about public law, because in that way of thinking, the past figures in rationality only incidentally when we are thinking about how to make progress towards a better future. We may have occasional reasons to pay attention to the past. Somebody was mean to us and we've got to take that into account in deciding how to deal with them in the future. But I tend to think that the past plays a deeper and more pervasive role in structuring the rational predicament we're in the present. And that's in some way an anti-utilitarian or anti-consequentialist thought, which I'd like to develop. And private law, to some extent, manifests the deeper and more pervasive concern with the past that I'd like to capture, if I can, just as does my concern with my own biography and with maintaining the life I've already got and other aspects of personal ethics.
So you're situating yourself, in a sense, in opposition to both Kantian, Rawlsian streams on the one hand, and consequentialist streams in political and legal philosophy.
I suppose I am, that's right, and I'm doing it by opportunistically juxtaposing two different themes. One is the personal life theme, and the other is the moral importance of the past theme. And bringing these two themes together can show that I'm not to be mistaken for either of those kinds of guys.
So what would you say to someone who'd say, well, maybe I can understand the significance of the past for personal morality, but surely the state, the law, should be outcome-oriented, should be thinking about producing good outcomes in the future? How would you bridge that divide?
I'm going to have several things to say to such a person. I'm going to say that that if they took that view seriously, they would be already very worried about private law and criminal law, both of which do much more with the past than that. To which some people might be willing to say, well, so much the worse for private law or criminal law. But I think I would also want to make the following point, that there are some kinds of progress which can only be made by thinking about the past, and not just in the contingent way that I already mentioned that a consequentialist might think this. So one way in which we want to make progress is we want to see to it that over time as many duties are performed as possible and as many reasons are conformed to as possible. And sometimes the fact that we already didn't do our duty or didn't conform to reasons leaves us with a question of what we're going to do about it now, what progress there is left for us to make. And I want to bring out that that feature is rather central to the thinking of private lawyers, perhaps in a rather purified and paradigmatic form, because I admit that, of course, other considerations, including considerations about deterrence and other regulatory concerns, have their role. I don't want to suggest that I'm going to join the Kantians in setting up yet another purist sort of theoretical private law which is divorced from the ordinary pressures of private law. But I suppose I'm going to say, as usual, that the consequentialist and similar considerations that are brought to bear on private law and which inevitably shape the way it develops and the details of its progress are addressed to a body of law which also has other things going on in it, including this deeper and more pervasive concern with the past.
Okay, let's take that concept private law that you've used. I mean, it's, I guess, an assumption of the lectures that it's a unitary area of law, even though maybe to the ears of a common lawyer that wouldn't come so naturally.
Yes. So, I mean, in a way, it's a little bit, I'm using the category a little bit ironically, because in some of the work that I'm associating with the Kantian tradition, private law is used to mark out a domain which is both unified and autonomous. And I'm obviously resisting the autonomy proposal. Am I resisting the unity proposal? Well, not yet. I'm keeping the option alive that in spite of it not being an autonomous domain, it's a unified domain. As it happens, I have some doubts about that, and I'm really going to concentrate more narrowly in the lectures on the law, what the common lawyers call the law of obligations, contract, tort, and some of unjust enrichment, leaving aside for another day, probably for another life, the question of where the law of property fits in.
Right.
Although I happen to think that it's natural to think of the law of property as another question coming pretty soon in the logic of the problem. And in that way, I have something in common with Calabresi and Melamed, who said the same from an economistic point of view. So there are some commonalities there as well.
Do you have any thoughts about what makes those three areas you've identified hang together as a coherent topic, and also what perhaps differentiates them?
Well, I think that the unity of the law of torts and the law of contract is easier to establish than the unity of those two things with the law of unjust enrichment. And one reason for that is that the law of unjust enrichment is still many things. It's still in a condition, doctrinally, where it answers to many influences and has some influences from the law of property and some influences from the law of trusts and so on, which are going to be hard to disentangle. So I'm probably going to have, that's why I said some of the law of unjust enrichment, because I'm not sure that I can build that into the model as well as I can tort and contract. But here's what I think about tort and contract, and I'm going to say this knowing that it's going to strike some contract lawyers as outrageous. The law of breach of contract is a special case of the law of tort. Not the whole of the law of contract, but the law of breach of contract. Breach of contract could be conceptualized without much loss as a kind of tort. It's a kind of tort which consists in failing to perform your voluntarily undertaken obligations. And contract lawyers who want to distinguish themselves from tort lawyers will emphasize that feature, that the obligations are voluntarily undertaken. But in doing so, they may, I think, perhaps distortingly, miss the continuity of the rest of what is done in the law of breach of contract with what's done in the law of torts. In particular, what I think to be really rather central to both of these things, namely the existence and conceptualization of reparative remedies. But not only that, that's just the central theme of the two areas.
And in your thinking about the lectures, have you come up with any implications for doctrine that lawyers might find surprising or illuminating?
Well, yes, it's funny. So I think one of the techniques that philosophers of law have to learn, which we all find tremendously difficult, is distinguishing between those distinctions in the law which the law has come up with, as it were, artificially to solve problems that are special to the law, and those that reverberate more deeply into thought. And sometimes it's a surprising set of them that reverberate more deeply. One that I'm quite convinced has deep significance is the contrast that tort lawyers draw between special damages and general damages. So special damages are damages in respect of loss of earnings and other quantifiable losses, hospital bills and so on. And general damages are damages for pain and suffering, loss of immunity, and other headings where the money sum merely represents in some figurative way the loss. And I think that difference between the literal and the figurative, if we can call it that, in the quantification of damages is of deep significance, because I think the rationale for awarding damages that are literally reparative, that match pound for pound the losses, the rationale is different, and in some ways prior to the rationale for awarding damages for loss of immunity and pain and suffering.
So does the significance you attribute to the distinction between general and special damages map on to something in the morality of personal life?
Well, I think that it's really just about the significance of the past again, the way in which we respond to the injuries that we leave behind. So imagine that you hurt somebody, and let's say it's a footballer or a pianist, and you're thinking to yourself, what would count as doing your moral duty by such a person? You might think that what you should do is get as close as possible to what you should have done in the first place, which is not to hurt him or her, and the way to do that might be in part to give him or her back what he or she would have had but for injuring him, namely a good season playing football or a nice concert tour. And of course you can't do that literally, it's too late, the fingers are not going to do it or the feet are not going to do it, but you can, for example, give that person back their lost earnings, or some of them, and you might think that that's what you morally ought to do, and you might think that that comes up right across life, and it's not a special private law problem.